At the time that colonies were founded in America, British charters required that colonial legislation conform to the common law of England. Accordingly, America adopted the traditions of a divided English bar which observed an inherent class distinction, distinguishing barristers from solicitors. The English barrister-solicitor model was a self-governing system, controlled by practitioners. During colonial days, attorneys did not devote themselves exclusively to the practice of law. At the time, attorneys were otherwise employed as merchants. As respect for the legal profession grew, so did standards for admission to practice. The local courts allowed individuals to practice law after passing an oral examination by a local judge. The examinations were given by each individual court. The American legal system followed the English model, which relied heavily on apprenticeships. For example, Massachusetts required 7 years of apprenticeship before admitting attorneys to practice. Following the Revolutionary War, bar standards were eliminated. This is commonly referred to as the period of Jacksonian democracy. The premise was that bar admissions should not be limited to those of the favored class. During this time, private attorneys conducted legal training in their offices. Over time, colleges began to offer programs for those interested in legal training. Since clerkships were still required, there was little incentive for legal candidates to attend these law programs. In order to attract students to attend law colleges, state legislatures began to offer the diploma privilege. Under the diploma privilege, law school graduates could be admitted to practice without examination. Gradually, there developed a preference for legal training by law schools as opposed to apprentice programs. Since 1842, 32 states and the District of Columbia have granted the diploma privilege. From 1870 to 1917, bar associations were becoming organized and were shaping the policy of the legal field. Eventually, the American Bar Association formally denounced the use of the diploma privilege. The ABA passed a resolution condemning admission without examination. Legislatures were influenced by the ABA and the diploma privilege began a gradual decline. Currently, Wisconsin is the only state which still uses the diploma privilege.